going to talk now about the Equal Protection Clause. The Equal Protection Clause first appears in the Constitution in the 14th Amendment, which is one of the 3 amendments passed in the immediate aftermath of the Civil War. We call those the Civil War Reconstruction Amendments. And what the Equal Protection Clause says, it's in Section 1 of Amendment 14, is no state shall, and I'm paraphrasing there, here's the quote, deny to any person within its jurisdiction the equal protection of the laws. Now, that's one of those general expressions with which it would be hard to disagree, also hard to know exactly what that was intended to accomplish or to whom it was intended to apply. One of the issues of current political interest, of course, is the who's a person question. We know that includes corporations, and we know because of incorporation, that means that all those First Amendment and other rights of free speech, et cetera, incorporate into the Due Process Clause, which also uses person, et cetera. That's a topic for a different day. But we don't really know exactly to whom it was intended to apply as of this point in our discussion, nor do we know exactly what equal protection was meant to cover. So what I want to do now is give you a little feel for the evolution in thinking about how to answer those 2 questions, but then spend most of our time talking about how equal protection analysis works now. So what I want to leave you with is the tools to confront an equal protection problem and say, oh, well, let's see. Let's just analyze that and actually come up with some sort of resolution satisfactory, at least to yourselves, if to no one else. And equal protection issues are the meat and potatoes issues for a lot of constitutional litigators. So we hear a lot about the Equal Protection Clause, as we do about the Due Process Clause, which, as I mentioned, we're going to talk about a little bit later. So we know that, what do we know? We know, as far as to whom it applies, that it is one of the Reconstruction Amendments. The 13th Amendment had already been adopted. That prohibits slavery. Abraham Lincoln himself evidently thought that that would solve all of the Civil War problems. You get rid of slavery and we're done. Turned out that wasn't true. All sorts of things happened afterwards in southern states during the process of Reconstruction that a lot of northern legislators thought were denying to freed slaves fair rights of access to the political process and to judicial proceedings and that sort of thing. That the 13th Amendment, simply by abolishing slavery, hadn't gone far enough to rectify what they perceived to have been the problems in large part giving rise to the Civil War. And so they pushed through the 14th Amendment, which includes this Equal Protection Clause. No state shall deny to any person the equal protection of the laws. So at a minimum, we can surmise that it was intended to protect the rights of African Americans from state governments in the South during the years immediately after the Civil War. That's the problem giving rise to the language. And for a period of time, it was believed by a lot of people that the Equal Protection Clause was a clause to protect the rights of African Americans. The Supreme Court didn't have the opportunity to address that for a couple decades. And when they did, they actually decided, no, it's larger than that. That may have been the problem giving rise to the Equal Protection Clause, but the language, any person, is broader than that, and we're going to apply it as written. The case that gave the court the opportunity to do that was the 1886 case of Yik Wo. Yik Wo, the operator of a laundry in San Francisco, he was of Chinese origin. He and a bunch of other folks were denied licenses to build wooden laundries, and people who were not Chinese were in enormous numbers granted these licenses to build wooden laundries. And so he took his case to the Supreme Court and said, this is a violation of equal protection. We, based on our national origin, are being denied equal protection of the laws. It's a violation of the 14th Amendment. We're being denied equal protection of the laws by a state. And the Supreme Court said, yeah, fair claim, and Yiquo won. So there we see an expansion to Chinese American. So race, national origin, and then it sort of expanded from there. Curiously and interestingly, and this is going to be the topic of a later talk, women didn't grab hold of the Equal Protection Clause until much later. They had other clauses, the women's rights movement did, that they used, including the Privileges and Immunities Clause, most especially. But women came sort of late to the equal protection game to use the Equal Protection Clause to protect them from discrimination on the basis of sex or gender. But other groups started using it, and now it's apparent that the Equal Protection Clause is available to practically anybody. If you are a member of a group defined by anything, then you can bring an equal protection challenge if your group has been denied something that other groups have not been denied. Now, I'll give you an illustration. Let's say you don't see too well anymore, and you go in to apply for a driver's license, and you take the vision test, and you don't pass, and you're denied a state driver's license. Well, what you've just experienced is a potential violation of the Equal Protection Clause, because the state is giving driver's licenses to people who have a certain visual acuity and denying them to people who have a different visual acuity. And you can file a constitutional challenge against the state for violation of your rights under the Equal Protection Clause. So groups of people, if you've got a common characteristic, you can file suit and challenge violation. The principle is, and this is a very fundamental and core principle, that all people, or at least people similarly situated, should all be treated the same. This is one of our core American values, not exclusively American, but it's a core American value. Individual rights and everybody's equal before the law, etc. Now, what do you do if you're a court when you get one of these claims? Surely it can't be easy for my driver's license person to win. I mean, really? Conversely, if I were denied a driver's license because I was African American, you'd think, well, that can't be right. You know, so how does the court evaluate these? And here's where this becomes complex. So everybody needs to sit up straight now. The court has developed over the years a three-tiered system of analysis for evaluating equal protection claims. And the tiers are based on one of two things: either the group that's affected by the classification. By classification, I mean you get to and you don't get to. So that's the classification. The group on the losing side is defined by something. And if it's defined by something that the court finds suspicious or suspect or historically problematic, then it's going to look at those cases really, really closely. Those suspect classes include classes defined by race or classes defined by national origin. If a state's doing the discrimination, they'll include classes defined by alienage, like if a state discriminates against non-citizens, and the court's going to look really, really closely at that. So those are our three classes for strict scrutiny that we're going to talk about for close examination. If the classification or the group that's affected by the classification is united by a characteristic that's maybe not quite so troublesome historically, or that maybe more often than in the first group of cases is relevant to differential treatment, then the court relaxes the examination a little bit, but it's still paying somewhat close attention if it's a classification or a characteristic that we have historically had problems with and that frequently is irrelevant. And the paradigm example there is gender, okay? Is gender. So if somebody says men can, women can't, well, maybe sometimes, because there are physical differences, but not usually. Most things, it's hard to see why it would make any difference. And so the court will look at that a little bit more closely. I'm going to do a separate lecture on gender in the Constitution. And we'll talk about the history of women in the Constitution, how all that's played out. And then the area of least concern are classifications where the criteria or the element defining the class is something that really isn't a problem, that frequently justifies differential treatment, and where we don't really have a historical a problem with adverse discrimination. So that would be visual acuity, for instance. Yeah, okay, so you see well and you don't really see well. So we don't have a history, and that is relevant to driver's licenses and all sorts of other things. So we're not going to pay as much attention to that. Now, that's the three tiers, three sorts of classifications. What's the analysis? So that's going to depend. And the first of those, I'm going to start from the bottom and go back up. If your classification is your differential treatment is based on a characteristic that's frequently relevant and that nobody really cares so much about, there's no real history of discrimination based on that characteristic, then the court's going to subject it to something called rational basis review. Rational basis review. And what that means is that if you've got that sort of classification, it's okay constitutionally if the classification is rationally related to a legitimate end of government. Rationally related to a legitimate end of government. So it's a two-part test. So let's do my driver's license. I come in, I'm blind, they don't give me a driver's license. I say this is an equal protection violation. So the first question is, well, are some people treated differently than others? Yeah. People who don't see very well don't get licenses. People who do see well do. Okay. And not just well, but above a certain defined point. Okay. Well, is that suspect class? No. So level of review is rational basis review. Okay. So is that discrimination rationally related to a legitimate end of government? Well, the state would argue and the court would find the legitimate end of government is safe roads, legitimate end of government, and is keeping people who don't have a certain visual acuity off the roads rationally related to that? Yeah. So it's fine. It passes equal protection challenge. The great majority of statutes that are passed discriminate in some way against somebody, or a lot of statutes do. But they're rational basis review statutes. You can challenge them if you want to, but most people don't because they recognize that this is rationally related to a legitimate end of government. I'm not going to challenge it, but you could. You could. Now, gender, as I promised I'm going to talk more about later, but I'll tell you what the level of review is. You'll be amused to know this was established in an Oklahoma case involving the rights of late teenage boys to buy beer at grocery stores. The Craig versus Boren case, and yes, it was our own President Boren who was the nominal defendant in that case when he was the governor. But the level of review that the court came up with for classifications based on sex was intermediate scrutiny, which is to say the classification is okay only if the classification is substantially related to an important end. It was a little harder than rational basis, but a little easier than the one we're about to hit. And at this point, you may be starting to scratch your head and think, what does that mean? Who decides what's an important end of government? And the court decides what's important and substantially related. And isn't there a lot of room to play with these? And the answer is yeah. But this is the best solution the court has been able to come up with for enforcing the statute. So the last of these categories is what we call strict scrutiny. And I'm going to talk about race in the Constitution too in a later lecture. But strict scrutiny requires that the classification be necessary to a compelling end. You'll also read narrowly tailored to a compelling end. So the reason you're doing this has got to be really, really important, classifying on the basis of race or national origin. And this has to be the only way to get there. And I'll tell you that the only times the Supreme Court has found that satisfied in the case of classification based on race or national origin, and these are famous cases, were the Japanese internment cases during World War II, where people were interned on the West Coast, put into camps, had curfews imposed against them on the basis of the fact that they were of Japanese descent. Didn't matter if they were U.S. citizens or born here. If they had Japanese ancestry, then they were considered a security risk, and they were taken from their homes and put into internment camps. That got challenged in a series of cases. The Korematsu case, for instance, and the Supreme Court looked at it and said it's a classification based on national origin. They use slightly different terms then, but the level of, we have to look at this closely. The level of review will be essentially strict scrutiny. You can only do this if it's necessary to a compelling end. And the end argued was safety during the war. And is this necessary to that, interning Japanese Americans? And the court decided, yes, it is. Now, was that the right decision? Doesn't matter for our purposes. The test was established and applied, but Congress subsequently has apologized for that, and the court as well, I think, came to regret Korematsu, and it's viewed, my own personal opinion, by everybody I know as having been a little bit unnecessary. No, Germans weren't interned and Italian Americans weren't interned, just Japanese Americans were interned. But that's the level of review that was applied, and it was applied in that case successfully for the government. In virtually every other instance, strict scrutiny is fatal, right? It's very, very hard. Now, the last thing I'll mention, and then I'll close because we're going to talk about these later, is that the challenge then in equal protection cases is identifying the classification, where is the line being drawn, identifying, if you're going against the statute, your client group as deserving of heightened scrutiny, strict scrutiny, and then you apply the test. And the government has to defend on the basis of whatever the appropriate level of review happens to be. The government, of course, in defending the statute, wants this to be rational basis. You want it to be strict scrutiny. And that's the litigation fight in equal protection cases. That's an introduction, and we'll continue with this topic in connection with gender and race-based classifications in future lectures. Thank you.
Freedom 101 is made possible by generous support from Woody Young and the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.